the signs when somebody is actually ready to start their own litigation practice?
If you want to be a litigator, if you want to litigate, अगर कोर्ट आना है तो बहुत ज़रूरी है कि for the first at least 2 to 3 years you go to a trial court.
What are the mistakes they are making initially, because of which they are actually not able to survive in litigation?
I think this is something that we all can now talk about because I've been over 13 years now in the corridor, and I think the biggest mistake is they don't write. Yesterday when I was arguing that brief, I was talking about murder, cold-blooded daylight murder. And I kept on talking about confession, the judge was not convinced. I talked about a forensic report that's awaited, the judge was not convinced.
The AOR qualification is one of the most misunderstood credentials in Indian litigation, right? So what is it and why do you pursue it? Welcome back to Why Law, the podcast that answers questions law students and young lawyers are too afraid to ask out loud. I am your host, Varsha Gupta, and this is powered by Bettering Results. Today's guest has built something rare, a practice at the Supreme Court of India, and she started where you might not expect. She walked away from medicine, class 11 and 12 in PCB, preparing for medical entrance examinations, and that was the plan initially. And then she stopped and chose law instead. Today, Shriya Maini is an advocate on record at the Supreme Court of India, one of a select group of lawyers who are authorized to file before the Honorable Supreme Court of India. She built that practice from one of the earliest batches of GNLU, where most lawyers would never reach today. She has appeared before the Supreme Court of India in matters that matter today. She has been part of the Supreme Court Legal Services Committee who cannot afford, and she teaches at Bettering Results, which is where Why Law comes from. She has been part of the Supreme Court Legal Services Committee, a body that gives legal access to those who cannot afford it. In this episode, she's going to tell us how to build a Supreme Court practice, how does it look like from inside, and the things that no one warns you about before you start over, and why she chose a career in law over medicine. This is Why Law, powered by Bettering Results. Shriya Maini, welcome to this podcast.
Thank you so much, Varsha. Go ahead, squeeze all my time that you have. Tell us.
Okay, so very interestingly, you studied PCB, right? And then you prepared for medical services examination also, but you walked away from all of it for law, right? So what actually happened? Can you tell us about it?
So it's been a very interesting journey for me because I was a science student, like you said. 11th and 12th, I was, of course, preparing for my medical entrances. I'm an only child. My mom happens to be a doctor, a practicing doctor, and my dad's, of course, a lawyer. So the entire house had a very mixed atmosphere. On the one hand, we were discussing everything to do with what would happen in an OT, in an operation theatre. And I think on the other, there were discussions about what would happen in a courtroom. The only sort of weighing difference was that we had my grandfather, who was also in the Ministry of Home Affairs. So I think law took over medicine somewhere, but my mother's nudge for PCB kept me going. So I think I studied medicine in terms of preparing for my medical entrances, but I realized that there was a part of me that was not fully convinced if I wanted to be a doctor. Any which way I cleared my AIPMT, my pre-medical test exams. Then we went to this college, which was in Pune, Luni, and I didn't really feel that, okay, I can spend the next 5 years here. So I think that's very important. There's something from within which tells you that this is your calling. And on top of that, of course, there was parental pressure from my dad to also look at this option. And there was so much conditioning and nourishing in terms of what could happen in the field of law, that opportunities galore. And that's from where I meandered to look up for a CLAT examination, because I think that time the uproar was there. CLAT was coming up as the first legal entrance exam. So it was a very mixed bag of emotions, and I think law fell into my lap more than me actually walking towards it. So I think that's what really happened.
Okay, so that's very interesting. And you said like you joined GNLU as one of the earliest, batches of CLAT. So what was it like? There was uncertainty, chaos, or excitement?
No, I think everyone who had reached GNLU at that point in time was very certain and sure that they wanted to be a lawyer to the extent of studying the law, because it's a very coveted exam. CLAT is one of the toughest papers in terms of figuring out which law school in the hierarchy that you get. So I think most of us, because at that point in time, there weren't that many national law schools. I remember it was 2008 and we'd freshly walked into this law school, which was not even a building. It was the old NIFT campus in Gandhinagar, and it was the people who made the place, really. So it was just students. They were class 4 government employee quarters. So we had a little kitchenette and a pantry each. We had law books that were given by seniors who were there. It was barely 3 batches that the law school had actually eventually passed out, and we didn't have a structured building. So my first 3 years of law school were actually spent out of these government quarters studying. The good thing was we had fantastic mess food. I think that was the great going in Gujarat at that point in time. It was a fun time. People were studying. We were very actively mooting. Post the 3rd year, we had a proper building. There was a huge grant that came from then CM, who's now PM of India. And he'd actually given a fantastic grant to the college. NLU Gandhinagar, I remember, had shifted from Gandhinagar to Koba. It was more closer to Ahmedabad, the High Court, etc. So everything sort of changed. The academic background started taking over. And GNLU, though, was uncertain and chaotic in terms of what we would do next. But I think we had a fantastic time moving and surviving. I think survival is what was taught there. So I think we figured out the way that, okay, ऐसे भी आप रह सकते हो जहाँ पे you have a bare minimum facility. We were a cosmopolitan batch, and I think when we shifted to the new campus, it was a proper library. We were spending days and nights studying. It was a proper computer room that we have, an IT room. All of these facilities in the first 3 years weren't there. So it was a radical shift for us also. But वहाँ जाके, once we reached the new campus, I think things changed, and that realization struck that we're in a national law school. So chaotic in terms of the infrastructure, but very certain in terms of what we were looking at, paving the law as a way ahead for us.
Right. So amongst all of this, like, there is a lot of debate whether you should choose corporate law, litigation, right? So when you were in GNLU, like, what it was about? Like, there was focus more on corporate law or litigation?
I'm glad you asked this question, because I think till date, and I smirked and I smiled because till date I'm asked this question, I just feel वो करो जो आपको अच्छा लगता है. I think whatever you can wake up to in the morning, whether it's corporate, whether it's litigation, whether it's commercial litigation, whether it's looking at matrimonial, whether it's looking at white collar crimes, anything that takes you closer to what you enjoy. Now that's something I can't teach you. That's something you have to learn on the way, and little nuances will tell you whether you like it. You do internships during law school. You'll get to know if you like a corporate setup. You probably, I remember I got a job with Amarchand Mangaldas when I had immediately passed out. I was on a PPO with Mr. VP Singh, and he had left the firm immediately when I joined. So even though I joined with him into commercial lit, it was never the same for me. So I think things can change with even the atmosphere, not necessarily just what you want to do, but also who your boss is, what kind of colleagues you have, what's the nature of the work that's coming your way. I remember I sat on a rejoinder for 30 days, and I just thought to myself, for 30 days, 3 hours you make a rejoinder. Today when I litigate, I give my junior a rejoinder to draft. It's barely 3 hours. So I think priorities change, needs change. But if I can answer that very simply from experience, sheer experience, and whatever little I've gained out of these years, would be that do what your heart says, because you have to wake up to it and do it every day for the bloody rest of your life, which is too much to ask for. So I would say that.
I definitely agree with you here that you should do something that you really like. So you said that you joined Shardul Amarchand, right? You got a PPO. So how many years did you work there before you chose to?
So it wasn't even a year. It wasn't even a year. I joined Amarchand in 2008, and before I knew it, I think almost 6 months. And Mr. VP Singh was the man who gave me a job. He was someone I'd interned with about 2 times over. He's with a very respectable law firm now. He switched law firms, and he gave me a job at that point in time. But I think that's when I realized that, this is not my calling really. I want to move out and get to a courtroom. So I think the biggest realization which Amarchand taught me at that point in time, because we didn't have SAM and CAM then. There weren't these two segregations. So for me, the parent firm gave me the way forward that, okay, you want to get to a court, but the law firm is not going to take you to a court. So if you want to get to a courtroom, then you probably need to venture out into the corridor. So I think the only one thing that I can actually say before I end this is that the art of communication and emailing skills, I think that's what Amarchand taught me very well. So I was completely into client dealing, client facing to the extent of corporate clients. So today I don't have a difficulty. If there's a man who's sitting from a legal aid with me, I can equally well talk to him. If there's someone who's an authorized representative of a company, I think I can communicate as well. So I think that isn't a problem. So little skills overall that the law firm culture teaches you. So nothing goes waste is what I'm essentially coming at. Every experience on the way, whether it's from a firm, whether it's from a court corridor, whether it's from law school, everything comes in handy. Absolutely.
Right, like you mentioned about, skills that you learned, similar experience I have also had when I joined Amarchand Mangaldas. So, client communication, emailing, and, ability to work like 24/7 is something that you will learn in a law firm. So I think that is always the case. So I want to ask you that great litigators have some sort of discipline that other people don't have, right? So is this something that you had initially or you developed it later?
So I think this takes me back to my questions answer that you had posed about PCB and 11 and 12th in science. I think science inculcates a discipline in you. It teaches you that, okay, there is so much demanding labor that it requires, and that too quality labor. So it's not just that you're waking up, mugging up a chemical formula and going, but you have to utilize that chemical formula, make a benzene ring out of it and produce a result where the equation matches. So I think there's so much of discipline that science inherently inculcates. That's one. That's very important. So little things that can actually work for you, that worked for me in my favor. Secondly, I went to a school which was extremely particular about reporting in the morning at 7:30. So I went to Mothers International School, and I think that school gave me so much in terms, I'm still in touch with the teachers. That school gave me so much in terms of just being on time, being punctual, being disciplined, meeting timelines. Everything was to be of a certain standard. Even if subah utھ ke kuch nahi hai, sirf jana hai, unit test hai, but that unit test is life today. So you have to attempt that test as if it's the best thing in your life. So that zeal, that passion, that vigor that it instills into you, coupled with the discipline, is a sure shot panel of success. I think there's nothing else that you need if these four things are with you. So school is very helpful. Law school was again very demanding in terms of being an NLS. Then Amarchand, like you said, I remember I used to come home at 4 a.m. in the morning, barely sleep for about 3 hours. 7:30 I'd be bathing and back up again. My mom would be packing tiffin. So I remember I was barely living at the firm. We had a bed that was there. Jisko neend aayi hai, wo jaake so jaye, वापस आ जाए. So these are normal nuances that I think we all have experienced. So all of these situations, experiences teach you, and discipline, I think, comes very inherently because you have to show up in court. Every morning, it's not a regulated, structured body, right? It's at the end of the day, we're an unregulated structure. Lawyers live on their own rules and terms. We're entrepreneurs, we're businessmen. So the more I work, we're also laborers. We're daily waged laborers. The more I work, the more I earn. The more I'm able to deliver justice. So I think the inherent want of waking up, showing up, and delivering is what discipline really instills into you. Yes.
So is there a lesson from your childhood, maybe a teacher, a moment of failure that still shapes how you approach a case today?
That's very interesting, actually. I remember my granddad, before he passed away, he would say this phrase very often. And he would always tell me, the eagles will come when I leave and you have to protect yourself. So I think that's the quote that has always stayed with me. And before he passed away, he would keep control of everything. He would keep the checkbook with himself. He would keep the keys with himself. So every time he was rushed to the hospital, he would always have them. But I remember the last time that we took him to the hospital, he renounced everything. everything. So I think that's the time I realized that he's really going to go and he's not going to come back. So I think with that legal luminary that I had seen in him, because he was such a strong legal influence over the generations in my life, I think that code really stayed on with me. And I feel now whenever there's anything, any case that I encounter, I think you should fight a case to win it. Because the opponent is an eagle, the judge is an eagle, the researchers on the opposite side are eagle, and maybe sometimes the law is also an eagle for you that can come and pounce and take the prey away. You never know, right? So maybe the law is against you, you're changing a proposition of law. So many new things can actually be there, yes.
And I think this is something a lot of people will relate to, that when we study in law school, like we spend 5 years there, and then we go to practice, it's entirely different, right? So 5 years of law school for you and day one of litigation, what was the biggest shock for you?
I think it's so true. This is really the biggest truth and the most hidden, latent truth that no one talks about. My father says this, और मैं ये liberty लूँगी इससे शुरू करने की. My father says वकालत सीखना, वकालत पढ़ना, वकालत सीखना, वकालत चलाना. ये तीनों बहुत ही अलग चीज़ें हैं. These three things are distinct from each other. So when you learn the law, you learn a bookish set of laws, legislatures, statutes. When you actually go and practice the law, you realize that it's absolutely nothing. That's your first starting point. That's just assumed prior subject knowledge. जो आपने पढ़ा है वो actually assumed है कि आपको आता होगा on the first date of your practice. But no one's actually taught you how to actually practice. That's where we need to fill in. That's the gap. And after that, for instance, I'll give you a very basic example. I remember Supreme Court Rules of Practice and Procedure, 2013. I passed out in 2013. So those rules were not even there. 2008 to 2013, I was in law school. So I never knew that there is a Supreme Court corridor which has its own set of rules which are going on since 1997 and even before that. Now, all of a sudden in 2013, when I passed out, these rules were amended. So we were never taught these rules. Nobody taught me this rule. Now when I came into practice, we heard, okay, we can become an AOR. My grandfather was very keen that, I do all these things. I go up until the apex court. So we heard about the AOR exam and I wrote it. And believe me, I wrote it as a fluke in the end because I was studying. I was going to the corridor almost daily and I wrote the exam. And I happened to clear it in my first go. But I was one of the youngest AORs there. And now also when I go to the registry, they ask me badge dikhao. They're not ready to believe that you can have these many number of filings in a year. But because we were COVID time AORs, we learned the electronic filing also and we learned the other one also. So what I'm basically trying to say is that it all comes a full circle at the end of it. Absolutely. Grab every opportunity.
So don't you think there are a lot of critical skills that law schools are failing to teach today?
Absolutely. I think we need to have, and we need to talk about these things. We need to have a separate, distinct unit which focuses on practical experiences of assuring quality professional help. So we're not just lawyers. We're also, like I said, quality help professionals. People are looking out for this. I remember my father and my grandfather talking about this on the dinner table very distinctly. I remember them saying CA and law. These are two things with the dynamic changes that we are seeing now, especially with GST, with so many taxation changes, with so many returns being filed. Everybody needs a CA. Everybody today needs a lawyer. And any lawyer, you will come in handy because all of these are realities of life. So I think law schools need to equip lawyers or other budding lawyers to become wonderful, fantastic lawyers who can practice the law, not just read the law. That's the difference that we're not focusing on. Have a distinct unit. Everybody knows how to draft a bail application, probably by looking at AI, probably by copying drafts. But how many people can argue a bail? How many times in law school are we told, okay, tomorrow there's a test, everybody will argue a bail matter. Whether it's a rape bail, whether it's a white collar bail, whether it's a murder bail, whether it's a robbery bail, whether it's an economic fraud 420 bail. Why are we, for the first time, Only in moots. And please let me tell you, moot courts are nowhere close to courtrooms. It's a good, fantastic simulation to prepare you. But believe me, yesterday I argued that matter which I was talking about, the cancellation of bail. I'm not going to name the matter, but it was almost as if there's a volley of questions coming from the Supreme Court in the partial court working days. And before I could finish my sentence, there was a next question. Then there was another, and I had to literally steer the bench. I managed to get a notice at the end of it, but it was an arduous task. It was a very interesting case. A senior police officer on duty shot a junior police constable. All the witnesses had turned hostile. Kith and kin family of the deceased wanted to challenge it. So I think law schools don't prepare you on how to conduct yourself in a courtroom to the extent of gaining relief. You have to win a case. That's the objective, right? Studying the law is great, but if it can't translate into an active litigation bliss, then it's of no use.
Right. And like coming from this, like what mistakes do you think fresh law graduates are making again and again? Like in law school, they feel, everything is very flashy. We will just graduate and, we will start arguing in court if somebody wants to go into litigation, right? But what are the mistakes they are making initially, because of which they are actually not able to survive in litigation?
I think this is something that we all can now talk about, because I've been over 13 years now in the corridor, and I think the biggest mistake is they don't write. With AI coming in, with technology, mobiles, how many people actually carry a notebook? So I went to Oxford. I was there for about 1 year. When I went to write my exams, the exams are still by hand at the University of Oxford. Most of the foreigners, the Goras, fail there. They cannot write an exam for 3 hours. We are blessed that in our schools, we are given examinations every year for 12 consecutive years to write by hand. Indians excel in foreign universities. And let me tell you, many of the British universities still exam by hand. So the first and the foremost thing is when you write. Why do the Japanese succeed? They write. And when you write something, there's an impressionable character created in your mind. So I think lack of writing, that's one. Number two, very important, people don't want to read the brief. Kids don't want to read today. Every time I go to argue, either I've drafted it myself or I must have read the brief 10 times. And I'm saying this, I still practice it. Only preparation can make you confident. It's a misnomer. ये झूठ है कि आपको confidence के साथ आप born होते हो. कोई नहीं born होता confidence के साथ. कोई किसी को नहीं आता. Everybody in the mother's womb knows nothing. Right? So I think very important, read the brief to the T. Very important, the art of reading. And reading would also mean researching. Fresh law graduates don't research and go. If there's a particular judgment that's pre-existing on a point, read that. And last mistake, I think, which they make, and the biggest mistake which they make, is they don't listen to their seniors. If you can learn from someone's mistake, I think that's the best thing. And we have the privilege of so many seniors in the corridor actually helping. So many kids walk up to us. I remember I have in my initial few years, my first 5 years, walked up to so many senior advocates and just asked, "Sir, I'm arguing this matter today. Could you please give me 2 minutes?" And they would actually stop and listen. I remember there's a sitting registrar also, I don't want to name him, in the Supreme Court. He's very, very kind till today, and he was in the mentioning branch. And I remember it was a very interesting story. In Supreme Court, it was my first review. And reviews are very rare to be opened in Supreme Court, Article 137 of the Constitution, my first review of my career. And I was a fresh AOR, not a fresh graduate though, but a fresh AOR, so very new to the Supreme Court corridor. And I didn't know how to mention a fresh matter. So they said, okay, go to the mentioning window. So I rushed, there's a counter there, and I rushed to the mentioning window. And I tried mentioning the matter, and they said, nothing doing, reviews are not urgent. This is not an urgent filing. We can't do anything to help you. So there was a clerk on the way, and he told me there's a registrar, a head registrar who hears the mentionings, go to him. So I went to him at that point in time, and he said, look, I can't do anything. And I started crying. I started pouring. I said, sir, mera naya brief hai, mera brief chala jayega. I'm a young lawyer, और review career में एक बार आती है, तो please एक बारी try करिए. So he said, beta, don't worry. Go to the chief's court. Try and mention there. I said, sir, I've never mentioned. He said, nothing doing, go and mention there. It was Chief Justice, now retired, UU Lalit's last day in the courtroom. 2 o'clock, he was supposed to now have his tea and then get up, and this is going to be a thanking ceremony by the bar, etc. I reached up to the chief's court. I was standing with these bigwiggies who were there, Mr. Singhvi, etc., who were there to thank him. And I had this little brief and I wanted to mention it. They actually gave me a turn. I mentioned my review. They opened my review in open court hearing the next day, listed it for hearing, and that SLP was restored and that review was allowed. So probably, I don't know if that kind of a brief will come ever in my career, but kadi se kadi jud jati hai. Everything flows if your intent is clear and genuine and bona fide. So I think the mistake that graduates really make is they don't listen to seniors. That one lead of just saying, go to the chief's court and mention it, led me to such a marvelous point, which I can look back and say with pride happened and I experienced it and I don't know if it'll come again.
Right. So litigation is one of the only profession where, people quit in the first 5 years, right? And it happens very frequently. So why does it happen, and what, especially with you, when such instances happen, how do you make sure that you continue in the profession?
So I think the attrition rate is very high, not just in litigation, even in corporate law firms, because of how demanding the profession is physically and mentally. It exhausts you. And for good reason. I think very, very often we see that we are reading for hours. My back is hurting. I'm very, very sleepy. I'm groggy. I'm grumpy. Because you're almost reading for about 8 to 10 hours. And it's not just reading. It's mindful reading. Okay, you're mindfully applying your mind. You're interpreting the law. And then you're applying the law to your particular set of factual matrix. And client dealing is another issue. You get a client, how you deal with the client, extracting money out of someone's pocket is very tough. किसी की जेब से 1 रुपया निकाल के दिखा दो. यहाँ पे आप कहते हो मेरी 2 लाख रुपए फीस है. It's not an easy job to reach there. So I think people can get very discouraged because money may not be the first return that may be certain for you. So I think uncertain returns is one of the reason why people really want to look for a different route. Another reason very often we also talk about is hard work. Every day, consistent hard work. You have to show up. You have to be in court. You have to have read your brief. There are no excuses in this profession. Sometimes, I'll give you an example. My grandmother passed away about 2 years ago, and it was on the day of my mother's birthday. And I had a matter listed and we lost her. I went to the ceremony in the morning, we cremated her, and then I went and I appeared for my SLP. I had to show up that day and I proudly showed up because I know if she would have been there, she would have wanted me to work. So I think you have to really feel the passion for the subject. And I think if you do, the gestation period is long, but the returns at the end of it are fantastic, monetarily and otherwise, let me tell you. It's a beautiful green pasture, but you have to wait it out. Patience, consistency, and sheer preparation with brilliant hard work. Sure shot.
Okay, so when you talk about hard work, right, there are lawyers who are working 14 hours a day and they still struggle financially. But there are lawyers who work less and earn more, right? So what's the actual difference?
So I think this is very personal in terms of what is earning for you and what is good earning for you. That's one. It's a subjective arena that we're now entering. Now, someone can say that, okay, I'm making about 4 lakh rupees a month and it's great, fantastic earning. Someone can say I'm making 1.5 lakh a month. I have 3 juniors who are working with me. I pay salaries of about 50 to 70,000. So I almost earn about 3.5 to 4. I pay the salaries off. I have a running office and I'm saving 1.5. Someone can say I'm working all by myself, I have a few interns, but I'm making about 4.5 to 5 a month. So I think happiness in terms of what you're looking at is very subjective. Yes, a lot of lawyers do make very good money with working a lot lesser if they are products of nepotism, if they have an initial few set of briefs. I came from a family which did have parents in the profession in terms of my grandfather, my father. My grandfather was from the Ministry of Home Affairs. So I think that substantially helps to give you a launch pad. That does initially give you a kickstart. There's no shying away from that. But what you make of it is going to determine how you sustain in the profession. So you may be able to get that initial set of brief, but you may not be able to sustain in the profession. Ultimately, your performance shines. Merit is going to be the king throughout. So ultimately, performance will shine. Not necessarily that you got those many briefs and you were able to translate it successfully into that many matters that you could win. I remember it was this senior advocate in the corridor who had once told me, and they were probably watching us argue. We were young counsels, freshly made AORs. We were fresh out of COVID. We didn't have exposure. And he looked up to me and said, "Beta, padhai karo, वापस आओ." So I think at times, little things can really make a difference in how you interpret a situation. May not have been my day. The judge may not have been in a mood to grant me relief. I may not have been able to strike out what's important. For instance, you keep on arguing a matter. It's a rape matter. You're constantly arguing about the innocence, about a plea of alibi, whatever, but your presence is confirmed by the semen. Now, no one has actually talked about the MLC. Half an hour, a junior counsel has argued a rape matter, not discussed the medical report. You'll never be able to get relief. Maybe a lawyer comes, discusses it the first. So you have to see where literally the bullet hits the nail. That is the art of lawyering. That is what you have to learn. So you can study for 14 hours and still not have it translate into a successful win the next day for your brief. And maybe you study for 4 hours, you've spoken to someone who's in the profession, an experienced lawyer. Perhaps I've discussed the brief with my dad over lunch. He said something interesting which struck with me, and maybe that's also the judge and his view tomorrow. So you really don't know where the odds are going to balance. It's a risk. It's a calculated risk. But like I said, preparation. Yesterday when I was arguing that brief, I was talking about murder, cold-blooded daylight murder. And I kept on talking about an extrajudicial confession. The judge was not convinced. I talked about a forensic report that's awaited. The judge was not convinced. I said witnesses have turned hostile, but they are being influenced. Judge was not convinced. In the end, I said there's a firing report and the firearm is confirmed and it's a heinous offense. Issue notice. But if I would have discussed this with my dad, perhaps he would have said these last 2 points the first. So I think smart work over hard work and consistency, of course, and discipline and experience and talking to people is something that you have to meander your way through and see what works for you in that brief.
So a lot of lawyers, come to us, they want to start their own litigation practice, right? So according to you, what are the signs when somebody is actually ready to start their own litigation practice?
I think this is a wonderful question. Because this, again, law school doesn't teach you and it doesn't discuss. They just assume that we are going to be out of law school and we'll be able to fly out of the bird's nest. But that's not how it works. I think if you want to be a litigator, if you want to litigate, अगर कोर्ट आना है तो बहुत ज़रूरी है कि for the first at least 2 to 3 years you go to a trial court. And try and go to a trial court which is of a metropolitan city, where you do have briefs of a certain pecuniary jurisdiction, civil side and criminal, where you're seeing essentially how a paper becomes a file. That's the creativity you have to learn. Because client एक कहानी लेके आता है, एक story, एक problem. आपके लिए वो story है. It's a story for you. It's a problem for him. He's breathing it, living daily. It's almost like a medical surgeon. You're operating, right? So he comes with a problem. It's a story that you hear, that he narrates to you. Now you have to find a solution to that story. You have to be a problem solver. So I think it's very important that this skill is inculcated and you keep this in mind. This is from where you have to start. Once you've solved the problem, you can find ways of how you're going to present it before court, etc. So that's, I think, something that you can look at.
The AOR qualification is one of the most, misunderstood credentials in Indian litigation, right? So what is it and why did you pursue it?
I think this is a big misnomer, and I think so many people are actually not even aware that AORs actually are such a handful. I remember when I wrote the exam, we were barely 1,200 into practice. So only 1,200 AORs were barely into practice. So I think name lending is such a phenomenon which has plagued the AOR circles. most definitely, most of the good, well-read AORs, advocates on records, are not doing a name lending process. I can say this with full vehemence. I can say this with full confirmation that most of us are very particular that if we are going to take up a matter, we are going to draft it or we are going to at least vet it. Because I'll tell you why. There's a method to the madness. There's a reason. Supreme Court has Supreme Court Rules of Practice and Procedure 2013, which give you a handbook of rules on the procedural filing. Now, if those rules are not followed, it's the AOR who's blamed. So the court will call the AOR in person. They literally summon the AOR. And AOR is the only advocate, as a specialized advocate, who's authorized to file a wakalatnama in the Supreme Court. So there's a reason for this. The reason is that there is a teaching, a quality teaching, a rigorous examination. And let me tell you, it's one of the toughest exams in the country on the legal side. It is not an exam which is plagued by Uncle Judge syndrome still. AOR examination is one of the most untouched exams when it comes to anything to do with either a sifarish or a nepotism or an Uncle Judge syndrome. That exam is a pure merit-based exam, 3 hours. So I think the good part about this is that the cream of the cream is coming, who's passing that exam. Age no bar, religion no bar, gender no bar, caste no bar, only basis merit. So I think that's the brilliance of this examination. So the whole cream of the cream feels very insulted, I would say. And I'm taking the liberty to use this word when we're told off that, okay, this is a field of practice where we give the petitions and they just file it. No, it's not like that. Please understand, times are changing. AORs are one of the most well-paid categories. There is so much financial stability because now even your sign carries a fee to it. आपके signature का पैसा है. So it is one of the best fields. If you're coming in from Pan India, if you're a first generation lawyer, this is one of the most safest fields of law to venture into, an AOR practice. If you love litigation and if you want to make a career as a litigator, this is one of the best arenas to enter in. And trust me, it's a very beautiful field. That's what I would say.
So once you become an AOR, what changes, like in the way clients see you, court interacts with you?
I think a lot changes. It's not only personal confidence that you instill, but it's also discipline. Like I said, you now become an officer of the court. The bar council essentially doesn't govern you anymore. So you're not answerable to a BCD. I don't know if you saw this video clip that went viral. I'm not going to name the lawyer. And she answered back a few days ago and she said, I'm an AOR and I'm not governed by the bar council rules. You may have this monopoly there. You don't have it here. So she was referring to one of the electoral challenges that were taking place and the BCD chairman was also there. So I'm just giving an example to say that your governing body changes, and that changes a lot. When your boss changes, everything changes. Your office changes, right? So you move up the corridor. And the most prominent change is this. It's a legal practice based on a question of law. District courts, sessions, trial courts, high court. Very different practice. 3 essential sets of different practice area. Trial court is a factual analysis of a court. We lead evidence. They take evidence. Section 101, 102 Evidence Act. What is the truth? What is false? We go into a witness box. We depose. High courts, supervisory, appellate, to an extent original. Okay, high courts oversee the working of the trial court. Again, a different practice area. Supreme Court, question of law. What is the infirmity in your impugned order? Are there concurrent findings of fact? So very different legal approach to a practice. So what changes is the approach to the practice changes, because now you're not just looking at what is the petitioner's stance, what is the respondent's stance. The client has a factual narration. He's told you that. Evidence has been led. Courts have appreciated. Now you're finding out what's the legal error in the judgment. So your readings increase, your analysis, your interpretation of the law changes. You're now sitting on a judgment which is passed by a division bench of the High Court by 2 62-year-old judges. And you're now deciding what is the infirmity, what is wrong in their order. So imagine the kind of confidence you feel.
In fact, a lot of lawyers, dream about building a Supreme Court practice, right? But very few are able to build it. So what actually goes there, like not just in terms of prestige, but what is the actual kind of work that you should and the skills you should inculcate if you want to build a Supreme Court practice?
I think the first thing you have to do is you have to have, and this is very important, non-negotiable, good trial court and high court experience. I think that's the first thing. If you really want to build a practice at the apex court, ensure that you spend about 2 to 3 years in trial. Ensure that you try and spend about a year over in the high courts. So by 5 years, when you're actually preparing for the AOR examination, you've done the lower court corridors. I shouldn't even say lower court now, I should say trial court corridors and the high court corridor decently well. Then when you come up to the Supreme Court, another important thing is please have a good mentor. I think that's non-negotiable. Very important. Like I said, experience can teach you. I think you can learn from other people's mistakes. I remember there was a very interesting brief that I got, and it was a case of there was a child rape. POXO was alleged, and they said 10 years rigorous imprisonment, and the accused came to us, now a convict, and he said, I want to file a criminal appeal. So I said, okay, we'll file an appeal, but what kind of a suspension of sentence are you looking at? And he said, I'm in jail, do anything, get me out, I'm innocent, and this and that. He had his own story. And we filed a criminal appeal, we filed an SOS request, and I noticed something very interesting. When I read the statement of the child, the girl child, she had stated that there was a legal issue of fingering and touch, which can mean very different things in POXO. So she'd stated something to say on the terms of touch. The police officer, the lady SI, when she was making the site plan, उसने वो छुआ का शब्द जो था हिंदी का साइट प्लान में वो चेंज करके फिंगरिंग हिंदी में लिख दिया. I'm not even going to say it across the interface. And the whole narrative changed from there. And this man was convicted of fingering, which is 10 years rigorous imprisonment, whereas touch carries 5 years rigorous imprisonment under the old POXO Act, the unamended act, which was applicable back then to him. So when we went in appeal, he had already undergone 5 years. So we still don't know if it was true. Had he really committed the offense? Had he not? But the courts had a judgment of their own. There's reverse burden of proof. The child was a star witness. She couldn't sustain her testimony, but because this was a case of POXO, he was convicted. The appellate court overturned when we filed the appeal and said, release him immediately. How can a police officer do this? This is lackadaisical approach. So Supreme Court, High Court, these are arenas of practice where we already have a fence. We have a set of rules. We have to play by those rules, and once we play by those rules, I think it becomes important that we use those factual evidences that have already been placed on record to the best of our ability to formulate questions of law. So Supreme Court practice in that sense becomes very different, and those are the kind of skills that you have to acquire. So if you're someone who's looking to build a practice in the apex court, I think start from scratch. Every day put a brick and you'll see a wall by the end of the day. It's literally like that. That's the best analogy I can give, because there's no shortcut to this success. It's not like overnight you'll wake up and you'll reach the fancy corridor and you'll have 5 juniors walking next to you. That's not going to happen.
Right. So let's get tactical for a moment, right? आप काफी सारे bail hearings में you have appeared, right? So can you walk us through 5 things that every lawyer should be knowing before they argue a bail matter at any level?
I think the first and the foremost thing that I would say is very important for a bail hearing is talk to your client. I've done bails which have ranged from rape bails, white-collar crimes, murder, theft, robbery, dacoity, everything. You name it, and I think I must have done it by now, because being on the legal aid panel, you get a lot of in-jail matters, in-prison matters. Also, otherwise, because I was handed over a few briefs over the generations, I have lived those briefs through the trial. So I think first and foremost, your client will give you the best defense. That's the defense which is your starting point. He will exactly tell you whether there's a plea of alibi, whether there's presumption of innocence to the extent of him never having met the victim. Sometimes people actually have personal acrimony. केस कुछ और होता है, बन जाता है रेप केस. प्रॉपर्टी केस होता है, सेक्सुअल हरासमेंट बन जाता है. So cross cases. So every time when you actually conduct a bail hearing or you're venturing into a bail, I think it's very important that you talk to your client. Second thing which I think is crucial, brief reading, very, very important for a bail hearing. Because it's not as simple as saying, okay, the person is in custody since so many days, there's triple test that's been followed, he's not going to tamper with evidence, he has no past antecedents. These are normal bail arguments which any judge knows. But hammering the facts in a bail is crucial. As many discrepancies you can take out between the initial FIR contents, the 161 statements of the witnesses, the 164 statement made by a witness before a magistrate, and finally how they depose in court if a charge sheet has been filed. So you have to literally sit on a drawing table and probably match these 4 columns and see what are the inherent inconsistencies, what are the contradictions. So that's the second thing. Hammer the facts for a bail hearing. Third thing, very important for a bail hearing, which is non-negotiable, is build your own story. You have to have your own story as a defense counsel. If you're for the victim, you've already alleged in the FIR. If you're for the prosecution or the complainant, your story is the FIR. That's already on record. As defense counsel for a bail, what is your client's story? You have to put out that story, that why are you implicated in this case? आपको क्यों फंसाया जा रहा है? अगर वो story missing होगी, you are never going to get bail. Fourthly, very different approaches between an anticipatory and a regular bail. Anticipatory is where there's imminency of arrest. You don't know if you're going to get bail or not. More uncertain. Preparation has to be on a very different footing and line. You have to build a defense. You have to actually come out and say, okay, I'm willing to cooperate with the investigation. You have to mentally prepare your client that, look, you may have to surrender. Last month, I think I filed a fantastic bail in the Supreme Court. I almost was certain that I'll get this bail. It was a 420 matter, cheating, criminal conspiracy, criminal breach of trust. I almost thought we were going to get this bail. But ultimately, the judges were not convinced. And the bench said nothing doing. Even though you may have a good case, it was a corporate fraud. They said, you'll have to go to jail. It's 420. Economic offenses, we can't grant anticipatory bail. If you have a case, surrender, apply for regular bail. We'll give you 3 days to surrender, 3 days for bail adjudication, for you to apply. So this is almost an unsaid way of saying, okay, you may have a case, but we can't. There are certain molds that we also have to follow. That's the fourth. And last but not the least, remember, bail is an adjudication preliminary on the facts. It's not on merits. So be very mindful that your bail defense is going to last your trial defense. So don't take up a defense which you can't sustain till the end. For instance, in a rape case, don't take up a plea of alibi that I was not there. If medical tests have confirmed your presence, if the semen presence is confirmed and you take up a plea of alibi, it's going to get rejected. So balance the odds of the FIR and the charge sheet. Take pleas which are going to sustain through the trial, which are logical. So I think these are things you have to be sort of careful when you're actually, of course, knowledge is ocean here. I really cannot map it for you as many number of bails as you do, because bails are extraordinary remedies. You'll be able to gain more experience.
I think what you have covered is very helpful for any young lawyer and even for general public, right? That how bail matters are actually handled. So you teach at Bettering Results, right? What made you decide to, teach also alongside an active practice?
I'll tell you, there's a very funny story with this. So I was working at the United Nations. I'd finished my Oxford studies, and there was a judge who used to come every Sunday to teach us there. And he used to take a flight. He was the sitting judge for the Mechanism for International Criminal Tribunals at The Hague. He was in the United Nations. It was a war crimes tribunal newly set up at Netherlands. So he used to come every Sunday. And I was one of the few Indians who used to wake up because his lecture would be at 9 a.m. So, and that too on a Sunday, because that was his off day from the tribunal. So no foreigner wanted to wake up at 9 a.m. and come for a class. So that was one of the very, very popular classes amidst Indians, because our parents would be probably going through the night time on Saturday nights. We used to have calls. So we used to be up again in the mornings on Sundays. So I remember 9 a.m. sharp, I used to reach All Souls College, which is still one of the most prominent colleges in Oxford. And I used to attend his session for about 2 hours. He would take a flight from Amsterdam down to London, come with on a taxi from London to Oxford, teach us and go back. This was his drill every Sunday. He was 84 years old. And what is interesting is at the end of the 9 months at Oxford, he offered me a job. He said, you come with me, I'll take you with me. I said, okay, but I need money. I need to be paid because, I can't go back and tell my father I'm again going to take money, even though I was on a scholarship in Oxford, but I needed money now to sustain myself. So he took me to the UN. And I remember Trump had parallelly been elected in 2016. We were all packed back. We were all sent because India was not willing to give funding. And he said, nothing doing. I won't let Indians continue. When I came back, Judge Meron made a call for me to NLU Delhi. So I think that was one of the most kind things he could do. And this is something I didn't even know. And NLU Delhi got in touch with me saying, we have position for an international criminal law faculty because that's what he would teach us there. And it was a subject of law which, like IPR, was developing at that point in time. India had still not signed the Rome Statute. So I literally picked up the call. I remember it was Mr. Bajpai. And I said, look, I don't have any experience in teaching. He said, nothing. We don't need anything. You just come. And I went there. And then I got a call from Salim sir, Lloyd Law College. And he said he's keen for a particular seminar and why don't I come there? And I still remember I went there, Varsha, I sat with him. I did this little seminar conference with him. And the next hour, he gave me a little book. And he said, Sunday se ye padhane aa jana. And I said, kya hai? He said, nothing doing. This is one of the guidebooks for the kids. Just go through it and come. My first class was horrible. I think I could not teach even a dime. But slowly, I think another few months and I picked it up. And then there's been no looking back. 2017 was my first lecture that I gave, that I started formally teaching. And now I'm going to make 10 years next year. So, yes.
So how did it, like you told how it started, right? But over the years, it has been like one of the best things that you have done, right? So especially when you teach at veteran results also, like I see a lot of lawyers, they love your sessions that you are conducting. They love the way you teach about litigation. So how has that, that perfection being built?
So I think at least I have to thank COVID. I don't know, we all went through different experiences in COVID, but I really have to thank COVID because during COVID, I had so much free time off my practice that I started teaching. And I remember that time I was doling out these courses by the day and almost all the class signatories were there and children would come up, lawyers would come up. And what is interesting is we are now going through an economic COVID. Nothing really has changed. We had a national COVID back then, 3 years of a deadlock. And again now we are going to face an economic COVID. So we are fairly and squarely in that same portion. So the only way to build perfection is practice. That's it. So the more you teach, the more you do, the more you go to court, the more you read, the more you hustle, the better you will be the next morning.
So now we are seeing that, everybody is talking about AI and lawyers, right? So according to you, is AI a big threat to litigation or it is the biggest opportunity the profession has ever seen?
I think not at all. I think AI is one of the better aspects that we're seeing, but it has to be used very cautiously. I think that's something we are forgetting. We're trying to replace humans with AI, which is not possible. Human practice and skill is irreplaceable. You can't replace it with AI. Otherwise, computers would be running the world, right? And they don't. Humans enable code into computers, and that's what robotic engineering or whatever sampling is today. So I think this is a misnomer, this is a myth that AI essentially can replace human skill. No, it cannot. That's one thing we need to understand. Second, AI is a fantastic guideline tool. Please understand this is something we need to imbibe because AI is here to stay. It's not as if tomorrow you're going to wake up and AI will be a factual myth. It's not going to happen. So you need to imbibe AI into your practice. Thirdly, AI cannot argue a bail. It's not possible because it will have a structured script. It will have answers that it can give. So you can't have a company engaging a computerized lawyer argue a bail, a white collar bail or an EDPMLA bail. So AI is never going to technically replace human thinking and knowledge. It's going to enhance. That's the thing. Now, fourth is right tool, which I think is very important, which we are not using. So if you have a good AI tool, Please use it. It's very helpful, but very mindful using again. I see a lot of kids, even in the office, interns, juniors, aggressively using AI, and they're not cross checking. I think data needs to be cross checked. Also, prompters. It's very important to do these courses, I feel, because the practical to reality conversion is very important, which is what I teach also. It's very important to use AI effectively. If you can actually use AI effectively, you can utilize time very well. And if you can cut short utilization of time, and if you can have a prompter giving you leads, why not? It's almost as if a senior correcting your draft, right? Here, essentials are being put without registry taking out 10 defects. You're drafting a good bail application, and then you can keep on adding your facts. But the crucial bit is check whatever AI has drawn up. Redo it, revamp it. So maybe not necessarily sit on a bail for 3 hours, but definitely sit on a bail for 1 hour. That's the difference. So AI is here to stay. It's going to do well. Accept it, imbibe it, walk with it, use it as a tool, and it'll be just fine.
And are courts in favor of lawyers who are adopting AI? What is the court stance?
So you're going to probably find this extremely funny, but I still, till date, I have an iPad, I have a marked set, but I will still any day like to go over my marked set. I don't think anything can replace the hard copy bliss. That can't happen. So courts are very mindful of it, that there is AI. I don't think courts are judgmental about it. Courts are encouraging that we use it, but we use it with checks and balances. I haven't till date seen a judge say that AI is probably the worst demon ever. I think they're very, very cautious about warning that if juniors do not check their drafts, which are driven by AI, then that's going to be a fallacious problem. So I think courts are very open. I think recently CJI, Justice Nagaratna, gave very interesting statements also on this. And I think it's a fair use if you can do of technology. I think technology is here to stay. You have to walk with technology. And I now see that so many judiciaries have gone paperless. Delhi High Court is completely paperless. We don't have the system of a file there. You can't inspect. It's all e-inspection, e-filing. Supreme Court, we are still doing a hard copy filing if we want optional with an e-copy. Trial courts, we are still doing a hard copy filing with the electronic copy. But High Court, Delhi High Court, for instance, is completely paperless. So virtual hearings are a big hit. But having said this, in hindsight, show up, go to court every day, because that's irreplaceable. As a litigator, you have to physically be in court. Nothing can replace the charm of a lawyer arguing, getting the relief with that adrenaline rush. And even the judges are as pumped to give you relief, and views can change. I remember, like I was telling you, yesterday, the judge was not at all with me in the initial first 15 minutes. But the last 20 minutes, the 5 minutes of those 20 were a game changer. So many things can change across the dais, across the bar. You really can't predict.
So now I have a rapid fire round for you. One skill that every law student must master.
One skill that every law student must master is reading. I think reading the brief, reading for the research, knowing what your brief is going to look like, arguing the brief as its basis is research. Nothing replaces quality and quantity research.
Okay, one mistake that every young lawyer must avoid.
One mistake that every lawyer must avoid. I think the biggest mistake is they don't listen to their seniors. Learn from experience. If someone is telling you that this is the correct route, please at least try and follow it. I remember, I'll tell you this little story with it. I was mentioning a matter day before, and I was in the queue. And I'd filed an IA for permission, seeking permission to file an SLP. Now in Supreme Court, we have this terminology which is called verification. So when a matter is verified, then we can mention it. This is the new rules by CJI Surikant. So he said that you get a matter verified, which means registry has cleared it. Now you can come and mention it. And I was standing there and I was not seeing a verified tick on my matter, the SLP. And I kept on standing there. I asked many people in the queue. No one told me. Then there was this really old person and he said, Mera naam Kamraj hai. Main Mr. So-and-so Natraj ka clerk hu. And I will tell you why this is not verified. I said, kya hai sir? What is the reason? He said, when it's an IA for permission to file SLP, we don't verify the main matter. We verify the IA. And trust me, Varsha, in minutes I mentioned the matter. And I was the only one in that line of unverified matters whose mentioning was allowed. But I never knew this rule because it was perhaps the first time I was also filing an IA for permission seeking for an SLP filing. So little things can go a long way. Listen. The walls will speak when you go to the court.
Choose one, research or arguments.
Oh, arguments any day, but researched arguments, researched based arguments. I think without research, arguments are going to be hollow.
One must read book that every lawyer should read.
I think Like a Lawyer. That's a very interesting book by Gary Fidel. I think that's something which talks about solid argumentative skills a lawyer should make. I think that's one of the good books.
Right. And what's the biggest myth about Supreme Court practice?
The biggest myth about Supreme Court practice is this, that you have to engage a senior advocate. You do not have to. You're as good as an AOR. You're as good as a junior counsel. In fact, this corridor is more fair than the high courts, if I can say this, and the trial courts, to the extent of listening to a counsel. Junior, senior, if you have a case, and very important, if you have a well-drafted SLP, a well-drafted brief, they are going to listen to you. Synopsis, list of dates, drafted well, they will listen. So it's a myth. Don't please waste money engaging a senior if you land up a Supreme Court brief.
Okay, what's the best legal advice you ever received in one sentence?
The best legal advice that I ever received in one sentence. Keep going. Don't stop. Like a horse with blinders, keep going. Arjun ki aankh. That should be your focus.
Okay, so there is a young lawyer who's listening to this podcast, right? In some city, maybe Kochi, Nagpur, Mumbai, right? 3 years into litigation, they're confused, underpaid, they don't know what to do. So what is your advice to them?
I think my first advice to them would be that I see you, I was you. Okay, I'm one of you, right? So if I can do it, so can you. There's nothing that's different. There's nothing that's immaculate about me. The only 3 things that I've kept to my chest is, and very importantly is, I've showed up every day. Consistency is key. Please do not give up. It's a beautiful world out there. Once you reach the hillock after that long trek, it's a beautiful 360-degree view of the Himalayas. So I think the whole arduous task to walk up there is totally worth it. The journey is very sweet-filled if you actually make it through. So I think consistency is key. That's one. Number 2, hard work. Nothing replaces smart hard work. Please don't hustle to the extent of haggling yourself, but it's very important that as a young lawyer, you learn everything that's around you, because anything and everything will teach you. Every brief will give you some knowledge that you will carry for life, and it's going to teach you something, and it's maybe not going to give you money, a very certain return at that stage, but it's definitely going to give you a certain knowledge. And that's going to help you translate it into a return in your next brief. I'll tell you this really funny story. There was this client that I got, one of my first few clients. I'd freshly come back from Oxford. I was taking an auto, and I was newly fresh in Delhi, and I was hustling an auto, and an auto cabbie driver stopped, and he said that, I'll carry you, madam. And he realized, because I was in the uniform, that I'm a lawyer. And he said, ma'am, मेरे पास पैसे नहीं हैं, मेरे पास 500 रुपए हैं, तो आप मेरा केस कर दीजिए. So at that point in time, I was very hungry for a client, very, very fresh. And I told my dad that I have a new client now. And he said, okay, that's great. Now, what is the case? I said, it's a hit and run, 279 and IPC. And he's going to pay me 500 rupees per hearing, which is going to be my petrol money to go to court. So my dad said, okay, do whatever the hell you want, fine. And I reached. And now, very interestingly, 2 months later, a very peculiar brief fell into my lap. This was an architect, and there was a hit and run, and a boy had suddenly jumped out of the bushes here in Arkipuram, and in front of the church area. And it was 3048, death on the spot. Now, that brief which I had gotten earlier, the 500 rupee one, was not paying me at all. Nothing. In fact, I was putting money out of my pocket. But the pace at which that brief was moving was much faster. So whatever I was doing here in the 3048 with this new brief, I had already experienced it there and tried and tested in the other one. So I was constantly going there, and many people kept on telling me until today that trial is pending in Saket courts. And many lawyers used to ask me, कि आप वो courtroom क्यों आते हो, वहाँ पे तो इतना कोई मर्डर रेप केस थोड़ी, आप AOR हो गए, आप क्यों आते हो? तो देन आई टोल्ड देम दैट आई सेड वो मुझे 500 रुपये देता है, दैट्स फाइन, बट आई लर्न सो मच फ्रॉम दैट ब्रीफ दैट आई वॉज एबल टू डू द नेक्स्ट brief so well that there's going to be an acquittal, I hope, in the next one. And that pays me very well. So you never know where something is going to come to benefit. So do everybody's case, help everyone. Justice is for all, irrespective of the money, the gender, the caste, the religion, and you're a carriage of that justice. You're a catalyst to the carriage of that justice. So use your skills effectively. I think that's very important.
So thank you so much for sharing your experiences with our viewers. It was a pleasure to host you on Vilo, and we hope to have more conversations with you.
Absolutely, my pleasure as well.
Thank you.
Thank you.